could lose the ability to use these tools and as a result may not be able to operate their firearm.
Maybe 3%, maybe 5%, but we're looking at what could have prevented 90% of the mass shootings.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
Certain bump stock devices, like the one used in Las Vegas, are illegal under current law.
Breaking news, a landmark Supreme Court decision shakes up gun laws. Get ready to rethink everything you know about firearm regulations as the court makes a game-changing move. Read on for the full scoop. Overview of gun laws in the United States. In the U.S., the regulation of firearms is governed by a complex system of state and federal statutes. These laws cover various aspects of firearms, including their manufacture, trade, possession, transfer, record-keeping, transport, and destruction, as well as ammunition and firearms accessories. Enforcement of these laws is carried out by state, local, and federal agencies, with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or the ATF, playing a significant role. The private right to keep and bear arms is constitutionally protected by the Second Amendment of the United States Constitution. Initially, this protection was not explicitly defined in legal terms until a landmark decision in District of Columbia v. Heller, 2008, where the U.S. Supreme Court ruled that the Second Amendment indeed safeguards an individual's right to possess firearms, independent of militia service.
It wasn't the fully automatic machine gun that was banned in 1986. It wasn't the bump stock.
That you said that all assault weapons should be banned. Is that a fair statement?
Certain bump stock devices, like the one used in Las Vegas, are illegal under current law.
Subsequently, in McDonald v. City of Chicago, the court held that the Second Amendment is incorporated by the Due Process Clause of the 14th Amendment. This incorporation means that the Second Amendment's protections apply not only at the federal level, but also to state and local laws. In the case of New York State Rifle and Pistol Association, Inc. v. Bruin, the Supreme Court made a significant ruling. It struck down New York's may-issue system for granting concealed carry licenses, which required individuals to demonstrate a specific need for self-defense. The court's decision emphasized that any regulation of firearms in the U.S. is presumed to be unlawful unless it aligns with the text, history, and tradition of the American legal treatment of the Second Amendment. This ruling has implications for how states and local jurisdictions approach the firearm regulations, potentially leading to a shift in the legal landscape surrounding gun ownership and carrying concealed weapons. In swift, the United States gun laws are a complex interplay of federal and state regulations, with the Second Amendment serving as a cornerstone for the protection of an individual's right to bear arms. Recent Supreme Court decisions have clarified and strengthened these protections, influencing how laws are interpreted and applied across the nation. Second Amendment. The right to keep and bear arms in the U.S. is a deeply ingrained constitutional provision protected by the Second Amendment. However, its interpretation and application have been the subject of extensive debate and legal scrutiny. It wasn't until two pivotal U.S. Supreme Court cases, District of Columbia v. Heller and McDonald v. City of Chicago, that the nature and scope of this right were definitively clarified. In the Heller case, the Supreme Court decisively affirmed an individual's right to own a firearm for personal use. This ruling overturned a handgun ban in the Federal District of Columbia. The majority opinion, authored by Justice Antonin Scalia, emphasized that the Second Amendment protects the right of law-abiding, responsible citizens to use arms in defense of hearth and home.
Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace.
Percentage of the shootings were done by semi-automatic weapons or rifles. The number one weapon that they use, basic pistol.
However, Scalia also pointed out that this right is not absolute. He highlighted that, like many other rights, the Second Amendment right is not without limitations. It does not grant individuals the unrestricted freedom to possess any type of weapon in any manner or for any purpose. For instance, concealed weapons prohibitions have been upheld, as have laws preventing felons and the mentally ill from possessing firearms. Additionally, regulations governing the carrying of firearms in sensitive areas, like schools and government buildings, as well as conditions and qualifications on the commercial sale of arms, are considered valid under the Second Amendment. A significant development occurred in 2022 when the Supreme Court, in the case of New York State Rifle and Pistol Association Inc. versus Bruin, affirmed the right to carry guns in public for self-defense. This ruling settled a long-standing dispute, as various federal appeals courts had previously issued conflicting opinions on this matter. For instance, the Seventh Circuit Court in 2012 held that the Second Amendment encompasses the right to bear arms for self-defense, both inside and outside the home. Conversely, the Tenth Circuit Court in 2013 maintained that carrying concealed firearms in public was not protected by the Second Amendment. The Ninth Circuit Court's 2016 decision in Berettas versus San Diego County similarly held that the right to carry concealed firearms in public is not guaranteed by the Second Amendment. Overall, the Second Amendment's protection of the right to keep and bear arms has been clarified through landmark Supreme Court decisions, with nuanced considerations for limitations and exceptions to this right. Recent rulings have further defined the scope of this right, particularly regarding the carrying of firearms in public for self-defense. Eligible people. Eligible individuals who can possess and own firearms within the U.S. include citizens of the U.S., nationals, though not citizens of the U.S., and lawful permanent residents, commonly referred to as green card holders. Additionally, aliens or foreign nationals who have been lawfully admitted to the U.S. as refugees, or those admitted under non-immigrant visas, may possess firearms under specific circumstances. This includes individuals admitted for lawful hunting or sporting purposes, those with a valid hunting license or permit issued by any U.S. state, official representatives of foreign governments accredited to the U.S. or international organizations based in the U.S.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
Partisans at the ATF have really run amok, infringing and trampling on the Second Amendment.
Individuals designated as official or distinguished foreign visitors, foreign law enforcement officers on official business, and those who have received a waiver from the U.S. Attorney General, provided it aligns with the interests of justice and public safety. However, non-residents of any U.S. state are generally ineligible to possess firearms, except when the acquisition is for lawful sporting purposes. Each state has its own set of regulations governing firearm ownership and possession, and there are additional requirements at both state and federal levels, including permitting and background checks. Controversy persists over the eligibility of certain groups, such as convicted felons, individuals with severe or violent mental illnesses, and those on the federal no-fly list. The specifics of these laws can vary significantly from one jurisdiction to another, and the enforcement of these regulations remains subject to change and debate. Prohibited people. The Gun Control Act of 1968 establishes a set of criteria that prohibit certain classes of individuals from engaging in various activities related to firearms and ammunition. These activities include buying, selling, using, owning, receiving, shipping, carrying, possessing, or exchanging any firearm or ammunition. The Act identifies specific categories of people who are prohibited from these actions. This includes individuals who have been convicted of a crime punishable by imprisonment for a term exceeding 1 year, those who are fugitives from justice, and individuals who are unlawfully using or addicted to controlled substances. It also applies to individuals who have been discharged from the armed forces under dishonorable conditions, those who have renounced their United States nationality, and those subject to a court order, including domestic violence protective orders, restraining them from harassing, stalking, or threatening an intimate partner or child of the partner.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
That's what gun control is all about. The ultimate goal is an unarmed and subjugated America.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
Additionally, individuals convicted of a misdemeanor crime of domestic violence are also prohibited. These specific categories are outlined in the ATF Form 4473, Firearms Transaction Record Background Check Form, which is used to assess eligibility for firearm-related activities. According to the U.S. Sentencing Commission, an estimated 5,000 to 6,000 prohibited individuals each year are convicted for unlawfully receiving or possessing firearms. In 2017, over 25.2 million background checks were conducted to assess the eligibility of individuals seeking to engage in firearms-related activities. It's important to note that these restrictions are in place to ensure public safety and reduce gun-related incidents, including suicides, homicides, and unintentional injuries, particularly in areas where firearms are easily accessible. Supreme Court's Bruen decision. The recent landmark U.S. Supreme Court decision on the Second Amendment has sent ripples through the nation's gun laws, causing division among judges and creating uncertainty about the scope of firearm restrictions. This decision, known as the Bruen ruling, introduced a new standard for evaluating challenges to gun laws, discarding the previous consideration of public interests like safety. Instead, the government defending a gun restriction must now demonstrate its consistency with the historical tradition of firearm regulation in the U.S. As a consequence, lower courts have been grappling with conflicting decisions on various federal laws, such as those targeting domestic abusers, felony defendants, and individuals using marijuana. Courts have struck down bans on possessing guns with removed serial numbers and restrictions on young adults in Texas. Additionally, Delaware's ban on homemade ghost guns has faced enforcement challenges. This legal turbulence, stemming from the most significant gun ruling in a decade, is likely to prompt the Supreme Court's intervention once again, providing further guidance for judges. Jacob Charles, a professor specializing in firearms law at Pepperdine University's law school, noted the widespread confusion and inconsistency in lower courts' interpretations of the Bruen decision. Laws that have stood for decades are now being challenged, as prior to Bruen, courts uniformly considered them constitutional. This legal wrangling unfolds against the backdrop of an ongoing surge in mass shootings across the U.S., as well as an uptick in violent crime.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
That men and women in this country have the right to defend their own lives.
Recent tragic incidents, like the shootings in rural Mississippi and at Michigan State University, underscore the urgency of addressing gun-related issues. In 2023 alone, several mass shootings have claimed numerous lives, including a particularly devastating event in California. The Bruen decision has emboldened gun rights activists who have seized on the opportunity to challenge a range of laws, from age limits to regulations surrounding semi-automatic weapons. For them, the ruling represents a significant step towards dismantling what they view as unconstitutional constraints on Second Amendment rights. Conversely, gun control groups are sounding alarms after a federal appeals court recently held that, under the new standards set by the Supreme Court, individuals with domestic violence restraining orders cannot be prohibited from owning guns. This decision has raised concerns about the potential consequences for public safety. Historical test in gun laws. The Fifth U.S. Circuit Court of Appeals, based in New Orleans, has recognized the well-intentioned policy goals behind gun control laws, aiming to protect vulnerable members of society. However, the court ultimately determined that the government failed to provide a historical precedent from early American history that closely aligns with the modern law. Attorney General Merrick Garland has stated that the government intends to seek further review of this decision. Gun control advocates have expressed concerns over the Supreme Court's historical test, but maintain confidence that many gun restrictions will withstand legal challenges. For instance, since the ruling, judges have consistently upheld the federal ban on convicted felons possessing firearms. They made it clear that the right to bear arms is confined to law-abiding citizens, according to Shira Feldman, litigation counsel for the gun control group Brady.
They were assaulted and shot by someone and couldn't defend themselves because their guns were taken from them.
Well, Mr. Wilcox, there's no law. Congress didn't pass it. That's a rule from ATF.
The use of this historical test has prompted debates about whether judges are well equipped to delve into history and whether it's reasonable to evaluate modern laws based on regulations, or the absence thereof, from the past. U.S. District Judge Carlton Reeves from Mississippi, appointed by President Barack Obama, expressed concerns about judges being tasked with historical interpretations when it comes to firearms regulation in the 18th century. Andrew Willinger, the executive director of the Duke Center for Firearms Law, noted that some judges meticulously scrutinize historical context, emphasizing differences between historical and modern laws. Others take a more flexible approach, aiming to understand the purpose of historical laws to the best of their ability. Numerous pending cases are being closely monitored by both firearm rights advocates and gun control groups. Among these are challenges to state laws that ban specific semi-automatic weapons and high-capacity magazines. The outcome of these cases will play a significant role in shaping the future of gun control laws in the U.S. Gun control legal landscape. The recent federal court ruling in Chicago signifies an important development in the ongoing debate over gun control laws in the U.S. The judge's decision not to block an Illinois law that prohibits the sale of assault weapons and high-capacity magazines is significant because it aligns with the Supreme Court's evolving stance on Second Amendment rights. This decision, based on the court's new constitutional test, asserts the state's authority to implement restrictions aimed at enhancing public safety. However, it's important to note that the legal landscape surrounding gun control remains dynamic. Despite this ruling, a state court has partially halted the law's enforcement due to a separate legal challenge. This partial block allows certain gun dealers to continue selling the restricted weapons, indicating the complexity and nuance in implementing and interpreting these laws. This included rules regarding the carrying of firearms in public spaces like parks and places of worship. While an appeals court has temporarily suspended this ruling for further evaluation, the Supreme Court has allowed New York to enforce the law in the meantime. One of the key points of contention among judges has been a law that prevents individuals under felony indictment from purchasing firearms. Some judges have supported this restriction as a measure to enhance public safety, while others have argued that it infringes upon Second Amendment rights and thus should be deemed unconstitutional.
Running for President of the United States wanted to strip away our enumerated constitutional rights.
These pistol braces make a normal, law-abiding person suddenly a violent criminal is bizarre.
Additionally, the case involving Delaware's new law regarding ghost guns highlights the ongoing legal battles in this domain. These firearms, lacking serial numbers, make it challenging for law enforcement to trace them. A federal judge issued an order prohibiting Delaware from enforcing certain provisions of this law. Conversely, a separate legal challenge to California's ghost gun regulations was rejected by a judge. In a notable commentary, U.S. District Judge George Wu in the California case expressed skepticism about how some judges are interpreting the Supreme Court's guidance on gun control. He implied that certain parties are selectively interpreting the court's decision, attempting to create an interpretation that overly prioritizes Second Amendment rights without considering the broader implications for public safety. This highlights the ongoing debate and diverse perspectives within the judicial system regarding the intersection of gun rights and public safety measures. Impact of historical context on Second Amendment interpretation. In recent years, the Supreme Court has significantly shaped the landscape of Second Amendment rights in the United States. Initially, the court affirmed the right for individuals to own guns in their homes, and more recently, it extended this right to include carrying firearms while traveling outside one's residence. This decision has been viewed as a milestone, but for some, it has also prompted concerns about potential restrictions on gun rights. In particular, the case of New York Rifle and Pistol Club versus Bruin has become a focal point in discussions about Second Amendment rights. This case hinged on a critical sentence articulated by Justice Clarence Thomas, which has since been widely cited in numerous legal proceedings. The game-changing sentence asserts that when interpreting the Second Amendment, it is imperative to consider the historical context surrounding the restrictions on firearms in 1791 when the amendment was written. Notably, during that period, such restrictions were virtually non-existent. This key interpretation has spurred a cascade of legal challenges across the country. Advocates for gun rights argue that under this framework, many existing gun laws may be deemed unconstitutional. This includes laws regulating various aspects of firearm ownership, such as bans on specific types of weapons, ammunition restrictions, and even personal carrying restrictions based on location. However, it is essential to underscore that the right to bear arms encompasses more than just firearms. It encompasses the right to bear any type of weapon, including knives, swords, and guns.
Now, what happened with Fast and Furious? With these traced guns that they lost, thousands of them.
That a firearm equipped with the stabilizing brace was, quote, would not be subject to the National Firearms Act.
This broader perspective on the Second Amendment brings into question the legitimacy of various restrictions placed on these weapons. As these legal debates unfold, The historical context of the Second Amendment continues to be a pivotal factor in the interpretation of gun laws. This raises important questions about the balance between safeguarding individual rights and ensuring public safety in the modern context. The ongoing dialogue on these issues is central to the evolving landscape of Second Amendment rights in the U.S. Impact of gun laws on crime rates. The impact of gun laws on crime rates is a complex and widely debated topic in the U.S. Different types of gun laws, such as those related to concealed carry permits, assault weapon bans, and waiting periods, can have varying effects on crime rates. Concealed carry laws regulate the public carrying of concealed firearms, and states have varying levels of permissiveness in issuing permits. Research examining the impact of concealed carry laws on crime rates yields mixed results. While some studies suggest a decrease in violent crime, others do not find a significant effect. A study published in the Journal of Criminology and Public Policy in 2017 reported that states with shall issue concealed carry laws experienced a 6.5% increase in violent crime. This disparity in findings underscores the complexity of evaluating the effects of concealed carry laws on crime rates. Assault weapon bans are aimed at restricting the sale of possession of firearms characterized by features associated with military-style weapons. The effectiveness of such bans in reducing crime rates remains a subject of debate. Some studies suggest limited impact on overall gun violence, while proponents argue they may help prevent mass shootings. Research indicates that waiting periods may be associated with reduced rates of firearm suicides. This provision acts as a deterrent for impulsive acts, providing a vital window for individuals in crisis to seek help or reconsider their decisions. This suggests that waiting periods can be an effective tool in preventing impulsive acts of self-harm involving firearms. Community engagement and intervention programs targeting high-risk individuals have shown promise in reducing gun violence. Initiatives such as Operation Peacemaker Fellowship in Richmond, California, and the Cure Violence program in Chicago have demonstrated success in curbing firearm-related violence within their respective communities.
Banning a class of weapons that you don't like the look of, not because of functionality.
Maybe 3%, maybe 5%, but we're looking at what could have prevented 90% of the mass shootings.
These programs represent a holistic approach to gun violence prevention, addressing the underlying social factors that contribute to firearm-related crime. Ultimately, the effectiveness of gun laws hinges on their enforcement. Stronger enforcement of existing laws, particularly in prosecuting illegal gun sales and straw purchases, can have a positive effect on crime rates. This underscores the importance of not only enacting comprehensive gun control measures, but also ensuring their rigorous implementation to achieve meaningful reductions in gun-related violence. Challenges: balancing rights and safety. The U.S. grapples with a long-standing and contentious debate surrounding gun laws. Central to this debate is the interpretation of the Second Amendment and how it intersects with public safety concerns. Challenges to gun laws in various states reflect the ongoing struggle to strike a balance between safeguarding individual rights and ensuring the welfare of the broader community. One of the core challenges revolves around differing interpretations of the Second Amendment to the U.S. Constitution. Some contend that any restriction on firearm ownership constitutes an infringement on their constitutional rights. This viewpoint leads to legal battles where the constitutionality of specific gun control measures is questioned, illustrating the fundamental tension between individual liberties and collective safety. Advocates argue that such bans infringe on their rights to own specific types of firearms, contending that these weapons are used responsibly for lawful purposes. Conversely, proponents argue that these bans are a necessary precaution for public safety, particularly in light of high-profile incidents involving assault-style firearms. The implementation and scope of background check laws have been subject to legal scrutiny. Disagreements may arise over the extent of background checks for private sales, as well as the accessibility of mental health records in these checks. Striking a balance between privacy rights and the need for comprehensive background assessments remains a persistent challenge.
Here's a 12-round magazine. This magazine would be banned under this current bill. It doesn't fit.
Why is the ATF trying to say a pistol's no longer a pistol? If you use a pistol brace, it's a short barrel rifle.
Red flag laws, which allow for the temporary confiscation of firearms from individuals deemed a threat to themselves or others, have also faced legal challenges. Critics argue that these laws may infringe on due process rights, necessitating careful legal consideration to ensure that protective measures do not unduly impede on individual freedoms. Restrictions on high-capacity magazines, which limit the number of rounds a firearm can hold, have been challenged on the basis of their potential impact on an individual's ability to defend themselves effectively. Balancing concerns about self-defense with the potential risks associated with high-capacity magazines is a key consideration in this area of gun law. Laws governing homemade or ghost guns assembled from unassembled parts have also faced legal scrutiny. Challenges may arise over the regulation and tracking of these firearms, highlighting the need for comprehensive oversight in an evolving landscape of firearm technology. That's all for this video, folks. Thank you so much for watching, and we will see you next time.